All right. John, this is Kurt Lash. It's great to have your voice here with us. Glad you could make it. My thanks to the Center for the Study of Constitutional Originalism for setting up the conference. And it's a pleasure and honor to be the lead-off presenter. I've been asked to set a good example and limit my remarks to 10 minutes. I'm not sure, however, whether or not this is a rule or more of a principle or a standard. Nor whether or not I need to meet the original expectations of that particular limit. I prefer to think of it actually as a term of art. And so whenever a group of law professors comes together and use that term, you can have actually surprising and unique definitions. But I will certainly do my best to stay within the 10 minutes. The paper that I'm presenting is actually part of a larger project. I'm working on a book-length investigation of the original understanding of the Privileges or Immunities Clause. This particular paper looks at the antebellum period and focuses on early antecedents to the use of the term privileges or immunities from Section 1 of the 14th Amendment. Now, most of us probably first came across the Privileges or Immunities Clause in law school when we first studied the slaughterhouse cases and the decision by Justice Miller denying the claim that a state-granted monopoly violated the 13th and 14th Amendments, including the Privileges or Immunities Clause of Section 1. He arrived at his decision by downplaying the textual similarities between Article 4 and Section 1 and the use of the terms privileges and immunities in both provisions, and instead focused on the citizenship clauses of both provisions, which were quite different. One which had to do with citizens in the several states and the other citizens of the United States. And according to Justice Miller, these two provisions protected completely different sets of rights, with Section 1 protecting only a very narrow set of federally linked rights. Among law professors and contemporary scholars and historians of the 14th Amendment, this is one of the worst decisions ever handed down by the Supreme Court of the United States. It would probably make most people's top 10 list of cases most deserving to be overruled by the Supreme Court. And in fact, for many years, I taught Slaughterhouse in a manner that also was quite critical of Justice Miller and his unjustified distinction between two clauses that were clearly textually related due to their use of very similar terms. But as I began to investigate the history behind the Privileges or Immunities Clause, I found myself bumping up against a lot of evidence which actually supported the distinction that Justice Miller drew in Slaughterhouse. As just one example, John Bingham's 1871 speech, in which he clearly and expressly distinguished between the privileges and immunities of Article 4 and the privileges or immunities of Section 1. And so as I began to go through the antebellum period, more of this evidence began to uncover more of it, so I put it together in papers, and this first paper deals with antebellum uses of the term, and then the next paper will actually take it into the 39th Congress. So what I'd like to do is, briefly present the evidence from this first paper, and then we'll have John respond, and then we can just open it up and discuss. The way I proceeded in putting the paper together was by beginning in terms of looking for occurrences of the individual words. I then looked for occurrences of the paired words, privileges and immunities. I then looked for those paired words occurring in the broader legal term that you find in Article 4, privileges and immunities of citizens in the several states. And then finally, I looked for historical analogs to the full version that you get in Section 1, privileges or immunities of citizens of the United States. Now, I should say right from the outset, my use of the term of art. What I mean by this is the use of words or phrases that could have unique or specialized meaning depending upon their context. You can take a more rigorous definition of terms of art, but my only purpose for using it in terms of the title in this particular paper is to highlight the idea that these individual words could take on different meanings and significantly different meanings depending upon their being embedded in a broader legal term. All right. As far as the individual words are concerned, if you look at late 18th, early 19th century usages, you simply find scores of references to rights and advantages and liberties and privileges and immunities. These words, it was a very rich tradition of rights talk during this time, and you could find it used in a variety of contexts. These words could refer to the rights of individuals or of groups, of institutions, of corporations, of states or sovereign nations. The words could be related to natural law, conventional law, political rights. There really isn't any single definition or core definition that you can come to if you just focus on the particular word. It was used in such a variety of circumstances. On the other hand, if you look for occurrences of the paired terms, privileges and immunities, you find when these two words are brought together, they actually, quite often, referred to a set of particular rights that were granted to a group or to an institution. And so it's quite common to find the words peculiar or exclusive or particular associated with privileges and immunities being granted by positive law to a particular group. So the usages, more often than not, didn't involve references to natural law, for example, that would belong to all persons, but instead referred to a particular set of defined rights that belong to a particular group. Extending the analysis a little bit more and looking for privileges and immunities of citizens, like you would find in Article 4, this idea of a special set of conferred rights takes on a little bit more of a definition. Most of us are probably familiar with Corfield against Coryell, probably one of the most famous Article 4 decisions by Justice Bushrod Washington. But long before Corfield was decided in 1823, there had been a jurisprudence developing regarding the meaning of Article 4. And a jurisprudence that actually had developed a definition that would remain fairly stable for the remainder of the century, much less up until the time of the Civil War. Right out of the gate, you have Campbell against Morris in 1797, talking about how privileges and immunities under Article 4 didn't mean all conceivable privileges or immunities, but only a certain limited set that were conferred by states and which had to be granted equal access to visitors from other states. That same idea is echoed by Chancellor Kent in the Livingston case. Again, the same kind of idea that the privileges and immunities of Article 4 grants sojourning citizens equal access to a limited set of state-conferred rights. Corfield picks up on that idea and gives it a little bit more flesh and blood, according to Justice Washington. This limited set of privileges and immunities involved those fundamental rights which states had always granted to their citizens since the time of the founding. But again, even under Corfield, he wasn't referring to a set of nationally granted rights, but instead was referring to a set of rights which had always been granted by the states, and which were important enough or fundamental enough that as a matter of comity ought to be equally extended to visitors from other states. All right. Corfield, of course, gets a lot of attention. It's viewed in a lot of scholarship as a fairly unique decision, particularly because of its broad language involving fundamental rights. But if you look at how it was actually treated in antebellum jurisprudence, and also with treatises like Justice Story's and later on with Cooley's in 1869, 1868, you'll find that Corfield was treated the same as cases like Campbell and as Livingston and as Abbott v. Bailey and as Lemon against the People and as any one of a number of Article 4 decisions. All of them were string-sided for the proposition that they were protecting or meant to protect visiting citizens a degree of equal access to a limited set of state-conferred rights. So the point that the paper makes is that this jurisprudence was actually fairly stable. Here we go. The sign said, "I have plenty of time." Plenty of time. Alongside of that jurisprudence, I also identified a separate jurisprudence which had to do with a different set of rights, and this has to do with the privileges and immunities of citizens of the United States. This terminology is most often associated with treaties, the language of treaties. For example, the 1803 a Louisiana Cession Act by which we got the territory of Louisiana, and it talked about providing the inhabitants all the rights, advantages, and immunities of United States citizens. It's described at the time in at least one newspaper as granting the inhabitants the immunities and privileges of citizens of the United States. And this is an example, again, of the words privileges, immunities, rights being treated interchangeably. And what renders them, is my understanding of the evidence, what renders them terms of art is when they are embedded in that broader term and that broader reference of belonging to citizens of the United States. The debates that actually, I think, best developed, or at least got the most robust discussion of rights, advantages, and immunities of citizens of the United States were the debates surrounding the Missouri Compromise and the admission of Missouri. You had slavery advocates insisting that the Cession Act granted them the right to carry slaves into the territory, but you had opponents of slavery claiming no. The rights, advantages, and privileges of citizens of the United States actually did not involve state-conferred rights, of which slavery was one and therefore differed from place to place, but instead only had to do with rights actually conferred by the Constitution itself, thus creating a distinction between state-conferred rights of Article 4 and the nationally conferred rights under the Cession Act. This same idea has been developed by a number of scholars, but in particular Michael Kent Curtis, where you can find examples of the Bill of Rights or provisions in the Bill of Rights during this period leading up to the Civil War, where those particularly enumerated rights were treated as privileges and immunities of citizens of the United States. We are now in the standard and principle period of our 10-minute limit. So in conclusion, luckily, what I think the evidence establishes is that you can find fairly easily two separate strains of analysis in political rhetoric and legal jurisprudence in the antebellum period. One having to do with the state-conferred rights under Article 4, and another which has to do with the privileges and immunities of citizens of the United States. And when you add to that the fact that you can find this distinction, when you add to that actually John Bingham himself, the gentleman who drafted Section 1, also embraced expressly this distinction between the two, then I think it at least raises the question, a question that hasn't been asked very much, about whether or not Justice Miller was actually onto something, and whether or not he was reflecting a true distinction that existed in antebellum law. Whether or not this was the understanding of a sufficient number of members of the 39th Congress is another question. Whether or not this was the broad public understanding by the public in 1868 is another question. But at the very least, it means that Justice Miller didn't draw the distinction out of a hat. Thank you very much.